Hey guys, I told you I would go live as soon as I saw the order come down from Judge Eugene Griffith Jr. in the Scott Spivey, the ongoing lawsuit that was filed by Jennifer Spivey Foley, and, she's the personal representative of Scott Spivey's estate, against co-defendants Weldon Boyd, Charles Weldon Boyd, and Kenneth, also sometimes called Bradley Williams. We left off last time we talked about this case. The judge issued a decision in court before adjourning for the day. He's not going to grant immunity to Boyd, but he said he was going to take under advisement arguments in relation to co-defendant Kenneth Williams and issue his decision today. So in a 19-page decision today, he has denied immunity under Stand Your Ground for Kenneth Bradley Williams. So let's read this. I haven't read it yet. We're going to look at this together. If you want to read along or just look at the filing, it's linked in the description of this video. Or at least I think I hit saved and it should be there. It looks like I hit save and updated my description. So it should be in the description to read this filing. It says this matter was before the court on motion by defendant Kenneth Williams for dismissal due to immunity pursuant to the Protection of Persons and Property Act. So that's a South Carolina statute. We're kind of just calling that South Carolina's version of Stand Your Ground. Present at the hearing for defendant Williams were L. Morgan Martin, that is the attorney with the stick. M. O'Brien Martin, that is the guy I keep calling Jim's twin. And Robert E. Lee, Esquire. We have a footnote. Also present and participating was Kenneth R. Moss, Esquire, for defendant Boyd, who also sought immunity under the Act. The two matters were consolidated and tried together by consent of all parties. The court's ruling with respect to defendant Boyd is addressed by a separate order. So we'd already heard, we knew that he wasn't really giving additional thought to that one. He decided pretty solidly no immunity for Boyd. And then we also had Mark Tinsley and Natasha M. Hanna and Lane Gooding, Hugh Gooding, and John Nichols for plaintiff Jennifer Spivey Foley as personal representative of the estate of Scott Ryan Spivey. The parties submitted written filings and the court conducted a hearing from February 17th through February 20th, 2026. After considering the testimony, evidence, and arguments of counsel, the court denies Williams' motion to dismiss because he failed to prove by a preponderance of the evidence that he is entitled to immunity under the Act on any ground. So let's go through the findings here. We've got, hey, everybody tuning in. Good to see you on a Friday. This action involves the shooting death of Scott Spivey by Weldon Boyd and Kenneth Bradley Williams. On September 9th, 2023, Spivey was driving on Highway 9 in Horry County. He began driving erratically, and according to the testimony, he engaged in, quote, road rage incidents with several drivers, some of whom saw him holding a gun. Boyd was driving his truck, pulling a trailer loaded with items he'd purchased at Tractor Supply, with Williams as his passenger. Boyd pulled out of the Tractor Supply parking lot and onto Highway 9, traveling in the same direction as Spivey. Boyd intended to continue on Highway 9 toward a farm he owns in Loris, South Carolina. This would have taken him past Camp Swamp Road, which intersects with Highway 9 about 9 miles from Tractor Supply. At some point, Spivey passed on Boyd's right, and Williams testified Spivey pointed a handgun at Williams. Almost immediately thereafter, Spivey pulled in front of the Boyd vehicle. Once Spivey pulled in front of Boyd's truck, he remained in front of the defendants throughout the ordeal. According to the testimony, Spivey, quote, brake-checked Boyd's truck several times when the defendants were in close proximity behind Spivey. One brake-check maneuver forced Boyd to drive onto the grass median to avoid rear-ending the Spivey vehicle, but Boyd quickly regained control and continued to, and this is the judge's wording, he's not quoting, he's just saying, continued to aggressively pursue Spivey's vehicle. The defendant's pursuit lasted from 5 to 9 miles. Boyd eventually called 911 to report Spivey's activities, and he remained on the 911 call throughout the remainder of their pursuit. We've got a footnote here. The footnote says, both defendants described Spivey's behavior as erratic, dangerous, and scary. Williams testified there was a lot that happened on the road that day which scared the, quote, hell out of him. Nonetheless, it is clear to the court that the defendants did not call 911 until well into their pursuit of Spivey, including a significant amount of pursuit at very high speeds, in excess of what was safe and the posted speed limits. So back to, that was the footnote. Both vehicles reached speeds in excess of 100 miles per hour during the extended and lengthy chase. Williams testified he took pictures of Spivey's vehicle because Spivey's conduct was scary. Williams conceded that they pursued Spivey for a long way in excess of the speed limit, although he maintained he did not know exactly how fast they went. Williams testified on cross-examination that he recognized immediately that Spivey was a danger, but in no time did he tell Boyd to stop the pursuit, ask to be let out of the vehicle, or insist they not turn on Camp Swamp Road or drive up to Spivey. Williams admitted that there was nothing that kept them from discontinuing their pursuit of Spivey, but that Boyd was angry when Spivey ran them off the road into the median. Spivey turned off Highway 9 onto Camp Swamp Road, and instead of proceeding along their intended route, the defendants turned onto Camp Swamp Road as well. Williams testified that as they started to make their turn into Camp Swamp Road, Spivey was stopped. Similarly, although he denied it during the hearing, video of Boyd taken the night of the shooting indicated Boyd saw Spivey stopped about many yards away when Boyd began his turn on Camp Swamp Road. Boyd also testified that he could see Spivey stopping because Boyd could see Spivey's brake lights when he told the 911 operator that Spivey was stopping and they were about to have a shootout. Critically, on the 911 call, Boyd also can be heard stating his intent to keep following Spivey and his awareness that he was about to have a shootout. Despite Spivey being stopped in the roadway and no longer posing an immediate threat due to his driving or otherwise, the defendants drove up towards Spivey and stopped a distance behind Spivey's truck. We've got footnote 3. Footnote 3 says, although the police sketch of the scene indicates Boyd's truck was parked approximately 75 feet behind the Spivey vehicle once police arrived, Boyd can clearly be heard on the 911 call, indicating that he was backing up after the shooting. Given the totality of all the evidence indicating the defendants' efforts to coordinate their stories and manipulate the evidence, the court finds the defendants moved Boyd's truck after the shooting in order to present their actions in a more reasonable light. Ooh, I love a spicy footnote. Regardless of whether they moved their truck after the shooting, it is clear to the court that the defendants were not, quote, ambushed by Spivey, as they claimed. So the decision continues. Spivey got out of his truck with his handgun down by his side and shouted to Boyd and Williams to stop following him. Boyd had his handgun drawn and pointed in Spivey's direction when Spivey exited his vehicle. Boyd began to fire at Spivey while Spivey was standing by the door of his truck. We've got footnote 4. Footnote 4, oh, that's a long one. Here we go. We've got 3 footnotes on this page, guys. 4 is taking up most of the page. So 4 says, although during the hearing and during their prior deposition testimony, both defendants carefully recounted essentially the same description of Spivey's actions once he exited his vehicle. It is clear to the court that the defendants' stories are simply not credible. Essentially, both defendants now claim that Spivey got out of his truck with his weapon in his hand, that Spivey was throwing his hands up in the air and yelling at them, that Spivey stepped into the oncoming traffic lane and began advancing on the defendants, that Spivey advanced as far as the back of his truck or slightly beyond where he racked his pistol in an exaggerated manner or, quote, matrix move, swinging the pistol around as he raised it, pointed his pistol at the defendants, and began firing at the defendants. Both defendants insisted Spivey fired first. As will be discussed in this order, so there's more to come, the defendant's description lacks credibility, and I find them incredible. First and foremost, nearly every aspect of their stories contradicts the eyewitness testimony of Frank McMurrow and cannot be reconciled with either his testimony, his 911 call made immediately after witnessing the shooting, or his on-site video interview made by police. Further, there was significant testimony, including but not limited to the testimony of the crime scene investigative detective Shell Neal Tomasi, that she diligently searched for spent shell casings from Spivey's gun along the side of the road, under Spivey's truck, and in the road that would have supported that Spivey advanced to or beyond the back of his truck before he began firing, but she found no such shell casings. Additionally, although Boyd insisted at the hearing that Spivey fired his gun first after advancing on the defendants, during cross-examination, Boyd was confronted with the video of him on the night of the shooting events, in which Boyd clearly told investigators Spivey was in his truck door when Spivey fired at them. The court finds Spivey did not advance, but was in his own doorway. Whew. In multiple calls. Oh wait, I'm reading the next footnote. That we're not at that one yet. We have another sentence. So after that footnote, the decision continues. Either while entering his truck or after getting into his truck, Spivey was struck by one round in the right side of his back near his armpit. Then we're at footnote 5. In multiple calls, Boyd states he is certain he saw Spivey's shirt crinkle or move when he shot Spivey, as Spivey was standing outside his vehicle. Spivey's shirt had only one hole in it, and that was the shot that killed Spivey as described above. The bullet's trajectory, traveling from the upper rear and side of Spivey's back, through his torso, forward and across his body, and lodging in the upper front side of his chest, is consistent with Spivey retreating when he was shot. So remember, that's like, my microphone's kind of, it was like here, entering here, and then it never exited. It stopped in his chest cavity over on the other side. And I think my YouTube flips my mirror image, but, you know, you get the point. As he was dying, Spivey emptied his handgun into the cab of his own truck as Boyd and Williams continued to fire into the cab of Spivey's truck. No projectiles from Spivey hit the Boyd vehicle. The court heard from numerous witnesses, some of whom witnessed the chase, and some of whom witnessed the gunfire. Boyd testified that Spivey stepped away from his truck and into the oncoming traffic lane, raised his weapon up, quote, Matrix style, in parentheses he says, or fully raised and pointed at Boyd's truck, but in a rotated position, and that Spivey then advanced on Boyd's truck and began firing his weapon. Williams gave nearly an identical account of the encounter. Both defendants claim they only drew their weapons after or about the time Spivey fired, despite evidence to the contrary. Boyd even testified that he had to drop his phone to then draw his weapon, while Williams testified he had to retrieve his gun out of his bag located in the floorboard of the truck. However, this testimony does not align with and is contradicted by other evidence in the case. Frank McMurrow, an independent eyewitness who was traveling in the opposite direction on Camp Swamp Road. Remember, Frank is the guy who his girlfriend or fiance and now wife or something was in the passenger seat, and when they fired, he was like trying to make sure she was down and out of the line of sight. And he stopped and spoke with the first officers that arrived. Frank McMurrow, an independent eyewitness who was traveling in the opposite direction on Camp Swamp Road, testified he drove past the Spivey truck as Spivey exited with his gun down by his side, pointed to the ground, and the slide was locked back, indicating the gun was not in firing position. So, footnote 6 here reads, Mr. McMurrow's vehicle could not have traveled past the Spivey vehicle had Mr. Spivey, in fact, stepped away from his truck and into McMurrow's lane. This is very thoughtful. This is very thoughtful, right? So if the story is supposed to be Spivey stepping away from the vehicle and into the oncoming traffic lane, which is what the co-defendants are saying, it was only like this narrow. It wasn't like a multi-lane highway. It was, one lane in one direction and one lane in the other. So if he's walking into the oncoming traffic lane, how is this guy driving right along? He'd be in the road that he needed to use. So very detail-oriented here. More importantly, Mr. McMurrow testified Spivey did not advance, step into the oncoming lane, or even threaten the defendants. According to Mr. McMurrow, Spivey would not even had time to load or raise his weapon before gunfire erupted from Boyd's vehicle. So, then it continues, McMurrow stated that Spivey never walked away from the open door beside his truck. McMurrow's windows were all down, and he heard Spivey yell for Boyd to stop following him. Completely inconsistent with the defendant's story, as McMurrow's truck reached the Boyd truck, he saw Boyd through the windshield already aiming his gun, two-handed grip over the dashboard at Spivey. McMurrow then looked at an side mirror at Spivey and stated that Spivey turned towards his truck and his arm only slightly raised, quote, just moved it, not draw, not come up. McMurrow stated that at that point, when his truck's headlights were even with Boyd's driver door, all hell broke loose from the Boyd truck as Boyd fired his weapon and appeared to empty his clip through the front windshield of Boyd's vehicle. McMurrow's testimony in this regard almost exactly recounts his initial description to 911 of seeing the driver of the white truck, Boyd's vehicle, empty his entire clip through the windshield. McMurrow clearly testified the first person he saw shoot was the driver of the white truck, which was Weldon Boyd. Significantly, in an unguarded moment during his cross-examination, Williams stated he was not aware of Frank McMurrow when Williams testified during his deposition about Spivey stepping into the oncoming lane of traffic or McMurrow's lane of travel. The admission undermines the defendant's claim that Spivey stepped into the oncoming lane, as McMurrow, who was traveling in that very lane, testified Spivey never left the area beside his truck. Audio forensics expert Dr. Robert Mayer analyzed Boyd's recording of the 911 call and concluded there were no sounds or evidence of gunshots by Spivey. Although the defendant's cross-examination of Dr. Meyer seems to focus on the soundproofing of Boyd's truck as the reason why Spivey's gunshots were not recorded, both defendants are clearly heard in multiple recorded phone calls describing hearing Spivey shoot his weapon 3 times after he re-entered his truck. The fact that they could hear the weapon discharge even after it was inside Spivey's truck significantly undermines their argument. The only testimony that Boyd's truck had some form of special soundproofing came from the self-serving testimony of Boyd. And we got a footnote here. We've got a footnote. We got a footnote about Boyd's testimony. The court heard testimony from Boyd that if he was going really fast and the motor was running at high RPMs, that the noise of the motor would be so loud that one could not hear inside the cab. Yet the conversation with the 911 operator was discernible while he was demanding much of the supercharged motor, maybe? Additionally, and I think we talked about that on stream, we're like, hey, we can hear this over the engine of the car. Like, you can hear when he's revving up and speeding up, but you could still hear the words. So the footnote continues. Additionally, the video shown of Boyd demonstrating the truck's fast acceleration, allowed by a large supercharged motor, the court observed the noise from the high revving motor was not overwhelming. Boyd's testimony is suspect in this regard as well. He said, hold on, we need to give Judge Griffith a little, every time he says something sus. Let's see. Where was this footnote? Let's go back to wherever we were. Up here. Okay. I highlighted it to help myself find it, and then I still couldn't find it. The defendants did not present any evidence at the hearing that the truck Boyd was driving was in any way equipped with soundproofing that would have prevented Boyd's recording from detecting the impulses from gunshots aimed directly at the microphone, parentheses cell phone, that were closer to the microphone than the shots from inside Spivey's vehicle. It was the defendant's burden to present any such evidence. Nonetheless, Dr. Mayer further testified that there is no indication that Boyd dropped or otherwise moved his phone immediately prior to the onset of gunfire, which contradicts Boyd's testimony that he had to drop his phone to draw his weapon. Similarly, Dr. Mayer testified that there are no sounds of Velcro or zippers being ripped open immediately before the weapons in Boyd's truck begin to fire. This evidence undermines Williams' testimony that he only got his weapon out after Spivey racked his gun and he began yelling, "Back up, back up." Additionally, on cross-examination, Williams admitted Boyd told the 911 dispatcher they, quote, had their guns out too, and Williams did not correct Boyd. So, acquiescence by silence. Importantly, Boyd was impeached on this point with his own secret cell phone recordings. In several calls, Boyd is clearly heard describing that he intentionally left his phone on and sitting between him and Williams so that everything would be recorded, including in one call with his mother. And just a quick pause here, but, I know that the plaintiff is asking for a jury here, but this does not seem like something you'd want this judge to decide all the way through to a final judgment. Because this could be, I know the standard here is preponderance of the evidence, but I feel like this same argument with the detail, this could be the judge, if it was his determination to make the final judgment call. He's got the pieces laid out here. We've got another driver enters. Blaze Ward gave a video recorded statement to Horry County Police and also sat for a video deposition. In the deposition, Miss Blaze Ward stated Spivey passed her at a high rate of speed and she saw he was holding a gun. She called 911 and attempted to follow him to keep him in sight. She saw the Spivey and Boyd trucks interacting, saw Spivey, quote, brake check Boyd, and saw Boyd's truck drive into the median, but then immediately drive right back onto the road, continuing the pursuit. Miss Ward admitted she was speeding and told the 911 operator she was trying not to speed. She testified she was going very fast to keep an eye on the 2 fast-moving trucks. She never checked to see how fast she was driving. She stated she perceived the danger and therefore stayed back at some distance, even though the 2 trucks finally began to pull away from her due to their excessive speed. Miss Blaze Ward testified that she and the 2 trucks greatly exceeded the speed limit. She stated there was never a period where Boyd was not pursuing Spivey, and after passing the Minuteman convenience store, they really took and off and reached some high rates of speed. So this is where we have a footnote again. It says GPS information downloaded by SLED shows extended lengths of time where Spivey's vehicle was traveling in excess of 100 miles per hour and reached speeds in excess of 113 miles per hour. So, pretty quick. Miss Ward fell back about 1/2 mile during this part of the chase, but still had both trucks in her sight. Ward stated that it appeared Spivey was not letting the Boyd truck pass him, although Boyd attempted to try to pass or get beside Spivey. She described Boyd as being on Spivey's truck like white on rice most of the time. Miss Ward described it as Boyd pursuing Spivey and agreed that what she saw that day was consistent with Boyd's description to his mother of chasing Spivey and being on his ass. Miss Ward saw the vehicles turn onto Camp Swamp Road and could see them from some distance back down Highway 9. She never saw Spivey fire a shot, but thought she did because the glass on Boyd's windshield was flying off. She later understood that this was because Williams was firing at Spivey through the passenger side of Boyd's truck's windshield when she finally caught up to the two trucks. So this was the supposed gotcha moment. Like, people were like, oh, she says she saw, this is the one who said she saw Spivey shoot, but then she totally changed her story when it came time for her deposition, because she didn't take the stand live and in person. She did a deposition like a week or so before these hearings, which is still under oath. And she explained something I think it's a testament to how witness testimony can work. You perceive something shattering, you might think that that thing got shot into. But without closer examination and knowing, like, hey, what side did the bullet initially impact? What side did it exit the glass? You might not know, none the better. So I think it's important that the judge is giving that context here. The court also listened to the audio of the 911 calls. During his 911 call, Boyd stated, "He's trying to run from me now, and I'm just going to stay with him." Boyd also told the 911 operator, "He's trying to run from me now." We have a footnote. This statement indicates Mr. Boyd's knowledge that Mr. Spivey was attempting to withdraw from any confrontation, and I think this is the critical point. Was attempting to withdraw from any confrontation with Mr. Boyd or Mr. Williams. And he puts in here State v. Bryant, a 1999 case, where an aggressor, here, Mr. Spivey, withdraws in good faith from a conflict, and that withdrawal is communicated to the other party, here Mr. Boyd and Mr. Williams, by word or act. The right of the aggressor to self-defense is restored. Certainly, driving over 110 miles per hour trying to get away from Mr. Boyd's pursuit indicates a reasonable attempt to withdraw, although it was not working. The court finds that Spivey clearly indicated by his retreat, his speed, and his defensive maneuvers that he was trying to disengage from any initial conflict. But the defendants brought on the difficulty by their relentless pursuit. And remember, the judge has already noted twice that the plan of Boyd and Williams, according to their own testimony, was that they were going to continue still on Highway 9. They had no reason to turn down Camp Swamp Road outside of this, whatever was Spivey, because their plans for later in the day involved going somewhere else that needed them to go further down Highway 9. So it's not like accidental, hey, we're both still going down the same street. We have the mistaken impression that this guy is still messing with us. That's to me what I think the judge is laying out, point by point. So back up here to his decision. Boyd also told the dispatcher, "He tried to run from me, I kept up with him." Boyd told the dispatcher further that, "We have our guns out too. We're armed as well. He keeps throwing the gun in our faces. I have no idea if he's about to shoot us. If he keeps this up, I'm going to put him down. And, sir, if this guy aims a gun at me, we're going to have to shoot him." These statements demonstrate that both defendants had drawn their weapons and were prepared to use deadly force while actively pursuing Spivey, contradicting any claim of purely defensive action. When Spivey turned off Highway 9 and into Camp Swamp Road towards his home and away from Boyd's stated destination of Loris, Boyd told the 911 operator, "We're going to keep trying to follow him." This decision to abandon their stated destination and continue pursuing Spivey toward his home demonstrates that the defendants were engaged in unlawful pursuit rather than defensive action. Following the shooting, Williams can be heard saying, "God damn it, Weldon, why couldn't you fucking leave him alone?" Williams falsely denied remembering making this statement in his sworn deposition testimony, despite the clear audio recording. Importantly, The defendants knew that the authorities already had Spivey's description, the description of his truck, the truck's license tag information, and that they claimed to be eyewitnesses to Spivey's erratic driving and road rage conduct. At no time did the 911 operator or anyone else advise the defendants to speed excessively, follow Spivey from 5 to 9 miles, weaving in and out of traffic, leave their intended route to Boyd's farm by turning onto Camp Swamp Road, or try to conduct some type of citizen's arrest on Spivey. The court also listened to and reviewed calls Boyd placed in the days following the shooting. We've got a footnote 10. Boyd had downloaded an application to his phone, which automatically recorded his phone usage, including the actual audio of phone calls to or from his phone. These calls are highly disturbing and demonstrate consciousness of guilt, lack of remorse, and celebration of the killing of Scott Spivey. In one call to his mother, Boyd stated, "He just ran me off the road and aimed a gun at Bradley Williams' head, and I was like, F this guy, and I chased him. Oh, I was on his ass, and his truck couldn't outrun my truck, and he knew it. So yeah, he was terrified." This admission directly contradicts any claim of defensive action, and establishes that Boyd was an aggressor who initiated and maintained the pursuit, with Williams as an active participant. During direct examination of Boyd, he claimed he was so upset by his truck that he could not look at it. However, during cross-examination, Boyd is heard in another call responding to his mother's suggestion that he replace the windshield in his truck, which had damage from the rounds he fired over his dashboard, saying he did not intend to do that, but wanted to ride around and show off the bullet holes. Yeah. In yet another call, Boyd tells his parents he sent Williams a message by social media telling him, "You got in the fight, you stayed in the fight, you didn't ask questions, and you didn't hesitate. You're an effing warrior." Boyd added, and Williams did. He got right in the fight, and he effing fought it out, and he did not stop until it was over. This is a time. This guy is a detailed... I want this level of detail for the Zach Adams decision, calling out what was sketchy about the prosecutors and TBI and the ATM video and everything. All right, where was I? As I sighed, my brain goes to another case. Okay, in one call with Williams, Boyd instructs Williams to delete their communications between them on social media so that the Spivey family could not obtain these messages, and if police ask, to tell them they communicated by other means. Williams is heard in the call clarifying the instructions, and then readily agreeing to Boyd's instructions. At the hearing, Williams admitted he willingly complied with the instructions to destroy evidence and provide false information to law enforcement. These are the actions of... these aren't? These are the actions of a just or innocent man? I think there's a typo. Although it is not necessary to draw a negative inference, the footnote, although it is not necessary to draw a negative inference from the defendant's behavior to destroy evidence in order to deny this motion, the court finds the defendants willingly destroyed evidence to prevent that evidence from being used against them. So another spicy footnote. We're going to make the record clear that I don't need to make this finding, but I want to make this finding. Perhaps the most disturbing call involved Boyd and Williams both laughing about the incident and joking that they were going to get teardrop tattoos to commemorate the fact that they had shot and killed Spivey. We have another footnote. Footnote 12 says, "A teardrop tattoo can have many meanings, but it generally, but not always, signifies the person has killed someone. In the context of this recorded telephone call between Mr. Boyd and Mr. Williams, I find that is the meaning they were ascribing to the desire to obtain teardrop tattoos, was to celebrate killing Scott Spivey." And you guys know me. Like, I would be the first to say, hey, you know what? Just because someone has a tattoo of ESPN doesn't mean it means every slime play nasty and that it relates to crimes committed at the behest of Jeffrey Williams, young thug. But if they had gotten teardrop tattoos, they're here talking about it as if it's like a sign of pride, a showing of pride, and that the tattoo for them would be in reference to the death of somebody else. So, pretty pertinent, pretty specific there. And I appreciate the footnote from the judge clarifying, hey, teardrop tattoo isn't only one thing. But here, I think they tell on themselves. What if footnote 13 is like, have you guys ever seen the show The Wire? And it just goes back to these recorded calls. Oh, man. Back to the decision, we have this callous celebration of taking a human life demonstrates a complete absence of reasonable fear for their safety and contradicts any claim the defendants acted in necessary self-defense. Discussion. The Act provides immunity. This is going back to what we're calling the Stand Your Ground statute for South Carolina. The Act provides immunity from criminal prosecution or civil action to a person who is found to be justified in using deadly force. This is 16-11-450, and we're also getting State v. Sithbury and State v. Servant Pavon. The General Assembly adopted the Act in 2006 with the intent to codify the common law castle doctrine, which recognizes that a person's home is his castle, and to extend the doctrine to include an occupied vehicle and the person's place of business. The Act provides, a person who is not engaged in an unlawful activity and who is attacked in another place where he has a right to be, has no duty to retreat and has the right to stand his ground and meet force with force, including deadly force, if he reasonably believes it is necessary to prevent death or great bodily harm to himself or another person, or to prevent the commission of a violent crime. And this is subsection C of 16-11-440. We've got a footnote. Footnote 13 reads, it's not have you ever seen The Wire? Or have you ever seen Dumb and Dumber? This is the only subsection of 16-11-440 that is applicable to the facts of this case. The shooting did not involve a claim that, and no evidence was presented that Mr. Spivey was in the process of unlawfully or forcefully entering a dwelling, residence, or occupied vehicle, or had done so, or was attempting to remove another person against his will from the dwelling, residence, or occupied vehicle. To the extent, so that's why we can't even look at subsection A, is what he's saying. To the extent defendants assert a right to immunity under subsection A, the court finds that defendants have failed to prove by a preponderance of the evidence that they are entitled to immunity under the subsection. Further, to the extent that defendants assert a right to immunity under the common law of self-defense, the court likewise finds they have failed to prove by a preponderance of the evidence any of the elements of common law self-defense. So, that was footnote 13. To obtain immunity under the subsection of this act, the person attacked must be someone who was not engaged in unlawful activity and was in a place where he had the right to be. Citing here State v. McCarty, the person seeking protection under the act must show, by a preponderance of the evidence, that he is a valid claim of self-defense, and the court must consider all of the elements of self-defense except the duty to retreat. So, footnote 14. Common law self-defense requires a person asserting it to establish 4 elements. 1, the person must be without fault in bringing on the difficulty. 2, the person must have actually believed he was in imminent danger of losing his life or sustaining serious bodily injury, or he actually was in imminent danger. 3, if his defense is based upon his belief of imminent danger, a reasonably prudent man of ordinary firmness and courage would have entertained the same belief. So don't use me as a comparison. I'm pretty scary. I'm probably not the ordinary firmness and courage. If the person, when it comes to seeing firearms, I'm out. To me, it's not reasonable at all to turn down Camp Swamp Road. Especially after hearing more and seeing the visuals of the distance and digesting how this chase was occurring. It was kind of a bit more gray before so much was laid out. But me, I do not think it's reasonable to turn down with a gun drawn already. Because in my mind, if you draw a gun, you're giving the other person a reason to try to shoot you first. So why would I even want to put myself in a position that I could just keep going on the highway? Why would I want to give someone a reason to pull a gun on me, where they would then be justified in trying to defend themselves? I don't want to be the one to be the hamster to experiment. So, and then 4, the person had no other probable means of avoiding the danger of losing his own life or sustaining serious bodily injury than to act as he did in this particular instance. And then only that last element, the duty to retreat, is not applicable under the Act. And then, let's see, that was up here. Self-defense, even under the Castle Doctrine, is predicated on the absence of aggression or fault on the defendant's part in bringing on the difficulty. The doctrine is for defensive and not offensive purposes. While the Act may be considered offensive, this is from State v. Curry. While the Act may be considered offensive in the sense that the immunity operates as a bar to prosecution, such immunity is predicated on an accused demonstrating the elements of self-defense to the satisfaction of the trial court by the preponderance of the evidence. Any act of the shooter in violation of law and reasonably calculated to produce the occasion amounts to bringing on the difficulty and bars his right to assert self-defense as a justification or excuse for homicide. A claim for immunity under the Act requires a pretrial determination using, so that's why we had to have these hearings, a pretrial determination using a preponderance of the evidence standard. The trial court must sit as the fact finder at a pretrial hearing, weigh the evidence presented, and reach a conclusion under the Act. Let's see. Thus, the relevant inquiry is whether the person asserting protection has proved entitlement to immunity under the Act by a preponderance of the evidence. Now remember, at trial, it's going to be on the estate, Jennifer Foley's, it's going to be her party's burden. Mark Tinsley and his co-counsel, they would have the burden to present their proof and convince a jury to the preponderance of the evidence standard that the death of Scott Spivey was unjustified. So, but this, for the purpose of this pretrial hearing, since the moving parties are the defendant trying to rely on the statute to say that they're immune from this action continuing further, they have the burden for this proceeding. In this case, there are conflicting versions of what happened at the point of the shooting on Camp Sump Road on September 9th, 2023. We've got footnote 15. Can we make it to 20 footnotes? More footnotes than pages, we'll see. Oftentimes, when the use of deadly force is in question, the only other witness to the events, the person who was shot, is dead. And again, I think it'd be interesting, like, what if Scott lived, shot, fired, and killed one or two of the co-defendants? Like, what if the outcome was reversed? Like, I always think it's interesting. I mean, there's self-defense cases where in different moments of the altercation, one person might be justified, and then the next moment the other person might be justified, or both sides could be justified, or not. Like, it's just, it's such a split second. It could flip-flop, it could switch. I always think it's just so interesting for that reason. And Antonio Brown, by the way, I got to double check the date. I think it's March 20th. It's closer to the end of the month. He has his Stand Your Ground hearing with Mark Eiglarsh. I can't say his name. Mark Eiglarsh. I think that'll be some good lawyering, interesting arguments as well. So if you're interested in stand your ground type things, that's a criminal matter. That's in Miami. Different state, different precinct, different jurisdiction, different parties, and again, criminal, not civil. But if you like self-defense stuff, if that hearing's recorded, we'll be watching that over here. So let's see. We were here. The judge... All right, so he's quoting here Stanton v. Elliott, noting in qualified immunity cases involving police shootings, courts should be careful at summary judgment to avoid simply accepting the shooter's self-serving statements and must consider all contradictory evidence. I hope that's actually evenly applied. Like, if this is the standard in South Carolina's case law, and they're supposed to apply the standard for qualified immunity cases when a police officer is facing accusations, I just hope the standard is applied consistently. If that's currently the standard, apply it to everybody the same. Not just a layperson gets this, and then a cop and or a friend of a police officer, someone who might be like BFFs with the police officer, gets special treatment. Just apply it consistently. It continues, the judge must ensure that the officer is not taking advantage of the fact that the witness most likely to contradict his story, the person shot dead, is unable to testify. However, in this case, there were several other witnesses to the events and abundant other evidence, including audio recordings and law enforcement videos, to assist the court in sorting out what more likely than not happened that day. So remember, preponderance of the evidence is a more likely than not standard. Footnote. In a separate order, this court found that Boyd's testimony lacked any credibility. The court held that one instance of Boyd's lack of credibility lies in the differing descriptions of Spivey's behavior once Spivey stepped outside of his truck onto Camp Swamp Road, and Williams' testimony mirrored this portion of Boyd's testimony. Comparing the description by McMurrow, a disinterested eyewitness, of Spivey's behavior to the descriptions given by Boyd and Williams, they are totally different. The court cannot reconcile those differing descriptions, even though McMurrow was looking through his vehicle's rear view or side mirror. There is a substantial difference in the accounts. However, as described above, McMurrow's account most closely aligns with the physical evidence, the lack of shell casings, the audio forensic analysis, etc., and Boyd's own video statement when interviewed the night of the shooting describing Spivey standing in the doorway of his own truck. The court finds neither Boyd nor Williams were credible in describing what happened once Spivey stepped outside of his vehicle. As mentioned above, Williams' account of what happened on Camp Swamp Road mirrors Boyd's account and also is not credible. Williams also, and well, let's footnote here a little bit. This Boyd's own video statement when interviewed the night of the shooting. So we've looked at some cases. We just looked at Reggie Dillard's case. Andrew Hayes is another example. Andrew Hayes is a great example. Andrew Hayes, when it came to what he was on trial for, a crime that we now know somebody else committed, Tammy Vance and Sarah Lucas Rydell, mother and daughter. All the interviews in that case, they're recorded, whatever. But Andrew Hayes, who was convicted and interrogated for 27 hours, that was not recorded, right? To me, that's sus. It sends off a big red flag. What if here with the judge here saying, hey, we have this disinterested witness, and even though he's looking through the rearview mirror, you know, it makes the physical evidence makes more sense with his version than it makes sense with Boyd's future version. But Boyd's contemporaneous version, which we only have because it was video recorded, we might not have that. If they didn't record this, we might not have that. So, you know, I think it's good to have things recorded. Let's see. The court finds neither Boyd nor Williams were credible in describing what happened once Spivey stepped outside of his vehicle. As mentioned above, Williams' account of what happened on Camp Swamp Road mirrors Boyd's account and also is not credible. Williams also describes Spivey as stepping away from the truck into the oncoming lane, raising his weapon in a sweeping and rotating manner, advancing on the Boyd truck, and firing first. As stated above, McMurrow's description belies that version. Again, the court finds it significant that Williams admitted he was not aware of what McMurrow would say when he gave his account of Spivey's actions. Next, no matter how the roadway... And the thing here is, the way this is worded is very much even if we had recorded calls of Boyd asking Williams to delete things and he just like panicked and deleted because he was scared that it would look bad for him, even if he didn't, in the moment, he didn't do anything wrong. To change and match your story to the point where now your own testimony is not credible is an issue. I think I could get around someone deleting messages. Yeah, it's a sign of consciousness of guilt. I get it. But at the same time, if you think somebody's going to accuse you, it could also be reasonable to not want to give them any ammo to unfairly use against you. If you believe you're innocent, why would you give someone something that looks bad when you know it's not bad? Right? I think that could be explained, although that might be difficult to convince a jury of. But because your testimony, your story changes, and you're changing your testimony away from what actually happened to match your co-defendant, you know, it's a whole different problem there. So then it says, next, no matter how the roadway conduct on Highway 9 is described, as a pursuit, as a chase, or as merely following Spivey, Boyd and Williams admittedly knew that Spivey there's a weird period here. The person they were following at a high rate of speed, trying to keep up with, had a gun. We have a footnote 16. Oh, this is a long one. Let me stop and say hey to the audience. We've got, I know, Factual Lie hopped in here catching up. Beta, good to see you. Happy Friday. That girl Melly in the building. Nem came in here. I think I saw, yeah, I pulled up Nem's comments out of the corner of my eye. Trey Keisha was like, I remember the Emmy showing us with the stick. The stick. The good news, you know, just for the sake of trial watching and any proceedings that come from this, I really enjoyed watching L. Morgan Morgan. I keep switching his name every time I say it. But the attorney with the stick and the longer hair, the bap, 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 bap guy. I actually really enjoy watching him argue and charisma his way through the court, making the judge laugh. So, you know, if Williams was given immunity, there would be no more stick lawyer in the court. So, oh man. We've got Darth in the building. Good to see you. I see YSL Kells again. We've got, hey, Aaron. Aaron's filling in for the other Aaron gang. Good to have you here, Aaron Olivia. You just got here catching up. Well, hello to past Aaron and hello to future Aaron. Amy E, the beautiful Amy E, with the reminder to hit that like button. Please do hit the like button, you guys. Always appreciated. You know, it helps get this out into the ether and keeps me going. Amy E, you know, good time to remind everybody, because I got lost. I kept talking about Club Classy, the Monday, Wednesday, Friday stuff at Classy's channel, their music competition show. It's like a wind down like 3 times a week. It's on its own channel now called Song of the Night. So if I was telling you like the last week, Club Classy over on Classy's channel, it's actually over on Song of the Night. I gotta grab that channel link and drop it to you guys so I don't make you guys get lost. But good to see you, Amy, and thank you so much for helping me out when I was lost last week. I was like, where is this? They don't do this anymore. And then I found you guys. So always a good time. Jerome Street in the building. Nice to see you right back. I hope you're doing well. Hope you are doing well. We've got Stephanie in the building. Hello, hello. Tony says hello. Did I clip that? Yeah, let me pull that up. Jerome, thank you for the 10 here. It says nice. Let me see. Did I add? I might have uploaded it already. I have it clipped. I just didn't preload it into... Oh, I've got too many files. I'll remove the Titanic video from the Brendan Banfield trial. That'll get the boot. I don't think any of us need to hear that bad flute again. I have a clip that's shorter, but for context, when I said bap, 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 this was Williams' attorney arguing for immunity the last day of the hearings that we watched.
He says at the end of the day, I don't know who shot first. And they're going to say, well, he said he heard, all of a sudden all hell broke loose, bap, 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 to indicate somehow that means that Mr. Spivey did not shoot first. It don't mean that at all.
So I've got that clip down. I'll swap it out now that we have the context. I'll swap it to just the bap baps. But yeah, that had me rolling. Oh, I got a whole new sound effect unlocked. And we got to get someone to put that on a track. Oh man. Yeah, exactly these reactions, Trikisha. The intimidating stick. Such a good time. Other People's Drama says, no, I missed the flute. It's uploaded on YouTube. You can go watch it. I could send you a link if you need it. Let me know. You can listen to the Well, don't forget, I made the video. I just put like the Brendan Banfield and the au pair together in this video, but the Bad Flute song is like, I don't know, like 8-10 years old. You can just search Bad Flute Titanic and you'll find it's a hilarious video of someone playing a recorder in a field. So always available whenever you want to listen to it on demand. Maybe go to Pandora and just put on a Bad Flute channel and see what comes up. So, but yeah, that is the new clip we have in the arsenal. I'll add it to the rotation, the Bap Bap clip, without all the talking around it. So we were at footnote 16. Let's get this sentence before. He said, next, no matter how the roadway conduct on Highway 9 is described as a pursuit, as a chase, or as merely following Spivey. Boyd and Williams admittedly knew that Spivey, the person they were following at a high rate of speed trying to keep up with, had a gun. So, footnote, is he going to tell us why that's unreasonable? Williams argued that he and Mr. Boyd had a common law duty to pursue Mr. Spivey until Mr. Spivey was stopped by law enforcement, citing State v. Null. And State v. Null notes, from the earliest times, the English common law placed a duty on every person who encountered another in the commission of a felony to apprehend him or to make outcry calling the community to pursue and take him. South Carolina statutory law permits a citizen to arrest another person upon certainty that a felony has been committed. And that's, let's see, statute here 17-13-10. Or in the nighttime under specific circumstances. And that's State v. McAteer, which describes the genesis, development, and operation of these two statutes, and holding there is no common law right to make warrantless citizens' arrests of any kind. In McAteer, the Supreme Court held the adoption of these acts in 1865 evinces a legislative intent to regulate all warrantless arrests by private citizens, and thus to supplant the common law in this field. Therefore, the only right that exists is statutory, and neither of the statutes places a duty on a citizen to pursue and arrest someone who commits a crime in the person's presence. And we've got State v. Wilson cited here. The use of the word may signifies permission. We love a good may, must, duty to, shall not. The word may signifies permission and generally means that the action spoken of is optional or discretionary. This is the ordinary significance of the use of the word may, and nothing appears to require that it be given any other meaning in the present statute. So he's just putting here a case that interprets the meaning of may. In any event, at no time during the events on September 9th, 2023, or thereafter up until this motion, did either Mr. Boyd or Mr. Williams claim to anyone that they were attempting to effect a citizen's arrest of Mr. Spivey. Significantly, in their deposition testimony, they denied ever attempting to make any citizen's arrest. Oh. Well, yeah. Kind of hard to, because, like, that's something that, like, we were chatting about that, right? We're watching these hearings. We're like, well, you know, some states have that thing. Is this, like, can you do that in South Carolina? You know, is this, like, if people have the idea that he's waving a gun around and they're worried that someone on the road is going to get shot, like, could this be a situation where someone could be the hero? Like, could this have been the situation where maybe the drivers in the white truck were the good guys with the gun and Spivey was the bad guy with the gun? But if you're sitting there, you know, that's just food for thought. We were just chatting. We're finding out, like, hey, maybe you could kind of make that argument, even though there's no duty to do it. But in your deposition testimony, you say you never tried to make a citizen's arrest. Well, now you're going to lean on that. What? So you can't lean on that as a defense argument now for the purpose of this proceeding. Because again, your own words make that incredible. So, oh man. Well, that was footnotes. That was, I like hearing the case law and like, hey, there's statute here, but there's really no case law that says there's a duty. I mean, the oldest case law that mentions duty, there's superseding case law now. Anyway, back to the decision here. By all descriptions, Spivey was acting foolishly on the roadway, but foolish behavior by someone does not require or permit someone else to act foolishly or aggressively in response. Driving in excess of 100 miles per hour trying to keep up with someone who has a gun is foolish and aggressive behavior that foreseeably brought on the confrontation with Spivey. We have another footnote. Footnote 17. All three parties presented evidence that described 1-second intervals during the pursuit. We saw like the maps at the like beep, 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 beep. I should say BAP. Forensic evidence established Mr. Spivey's vehicle reached at least 113 miles per hour at one point and often exceeded the posted speed limit by more than 10 to 25 miles per hour. Yet Boyd was able to maintain a close proximity to Spivey's vehicle, footnotes going on the next page, throughout the entire pursuit, and to stay extremely close to Mr. Spivey's vehicle, like white on rice, according to Miss Ward. He wanted to say that again. All right. Lastly, the telephone calls Boyd made following the shooting demonstrate that defendants trying to get their stories straight, trying to get help from law enforcement, and trying to make certain that they were going to be free and clear of any responsibility or liability. This is particularly true of the telephone calls between Boyd and Williams in the days following the shooting. Williams' motion to dismiss. As the passenger, Williams certainly occupies a different position from Boyd. However, while Williams has better credibility than Boyd, his testimony mirroring Boyd's version of the moments immediately leading up to the shooting is not credible. And that's what I paused when I was ranting on earlier. Like, there are things that I think you could explain and say, well, hey, that wouldn't rise to me, for a criminal prosecution voting to convict. That wouldn't rise to me thinking he's responsible fully for a wrongful death suit. If he just, maybe after the moment, he had an awkward way of dealing with things. Like, certain things can be explained. But again, when your own testimony becomes contradictory, when you change your statements in very material ways that aren't just like, I don't remember a detail 10 years later, that's really problematic. And I think the judge lays this out well here. While Williams had better credibility than Boyd, his testimony mirroring Boyd's version of the moments immediately leading up to the shooting is not credible. The critical moments, the things that are the most important for you to remember to make your case here for some type of immunity, understand your ground. That testimony is belied by the other evidence as described above. Further, although Williams may not have wanted to initiate or continue the pursuit, nor was he in a position to control how fast Boyd drove during the pursuit, he willingly went along with it and encouraged the encounter with Spivey. And remember, when he testified, he said that he still didn't think, he's like, yeah, I did say, I did tell him to, back up or whatever. But he ultimately said that he didn't think Boyd's actions were unjustified. And maybe he genuinely believes that. Maybe he feels like he has to say that because he thinks the two are married together. Maybe at one point he didn't think that, and today he does think that. I don't know. But I wonder if this would be a little bit of a different outcome if Williams didn't change his story from his first statement. Because the judge is really spelling out, he is more credible, but, and he's spelling out that but. As a passenger in the truck, Williams owed a duty to warn Boyd to stop the pursuit or demand that Boyd permit Williams to leave the truck. Williams did neither. When a gratuitous passenger becomes aware that the automobile in which he is riding is being persistently driven at an excessive and dangerous speed, the duty devolves upon him in the exercise of due care for his own safety to caution the driver and, if his warning is disregarded and speed unaltered, to request that the automobile be stopped and he be permitted to leave the car. So that's citing here to Lynch v. Alexander from 1963. The key is whether a person of ordinary care would have left the automobile if given a reasonable opportunity to do so. And that's Thompson v. Michael. 1993, a passenger has a duty to warn and demand that a car be stopped if the car is being driven in a reckless or careless manner, and there is a reasonable time and opportunity for the passenger to give such a warning and make such a demand to be let out. Here, Williams breached the duty. And this might have gone another way, but that 911 call, there was a decent amount of time that 911 call, which we got to hear because 911 records, we would still have that 911 call even if Boyd didn't have that phone recording app on his phone. That's still something that we would have had available. And that's a bad fact for Williams for the purpose of his motion to dismiss. He's not on that recorded call stop, oh my God, I don't want to pursue him. He has a gun, we should stop. It's not reasonable for us to chase him. What are you doing, Boyd? And the judge is looking at that, the absence of that, and saying it's acquiescence by his silence. So Williams admitted that while he told Boyd to slow down as Boyd was getting close to Spivey's truck and to back up on Camp Swamp Road, he never warned Boyd to stop driving at excessive speeds throughout the extended pursuit, nor asked to be let out of the vehicle. Further, the evidence demonstrates Williams recognized or perceived an actual danger at the very beginning of the extended pursuit, giving Williams more than ample time to ask to leave Boyd's vehicle during the pursuit or demand Boyd stop the pursuit. He remained silent. So again, that's that he's acquiescing. The act was meant to codify the common law castle doctrine with the exception of the duty to retreat. So 16-11-420A, it is the intent of the General Assembly to codify the common law castle doctrine, which recognizes that a person's home is his castle, and to extend the doctrine to include an occupied vehicle and the person's place of business. State v. Jones, noting subsection 16-11-420A, extended the castle doctrine's protection, when applicable, to include an occupied vehicle and a person's place of business. The purpose of 440C was merely to extend the common law right under the castle doctrine to other places where a person has the right to be. It was not the intent of the General Assembly to sanction the use of deadly force for someone who willingly extends participation in a road rage incident with someone who the shooter knows is armed, is acting foolishly, and is attempting to withdraw from the situation. Conclusion. To be entitled to protection under the Act on any ground, a person requesting immunity must, this is a person requesting immunity must prove his entitlement. We're going to say it's must prove his, Person requesting immunity must prove his entitlement to immunity by preponderance of the evidence. It's their burden, so it should say must. This court is of the confirmed belief that credibility is the crux of task of the fact finder. In this case, the court is the sole fact finder. The court has weighed and evaluated every witness and all evidence presented at the immunity hearing. After conducting the mental exercise of weighing the evidence of whether Williams is entitled to immunity, the court finds that the scales remain unmoved. Williams did not meet his burden of proving he was entitled to immunity. Accordingly, for the reasons stated above, as well as the reasons argued in plaintiff's memorandum in opposition to defendant's motion to dismiss, and the facts cited therein, the court finds that the defendant failed to satisfy his burden, and Williams' motion to dismiss on the grounds of immunity under the Act is denied. And that is Eugene C. Griffith Jr. I think we heard that his nickname was Bubba, the judge. So, there you go. That is, to me, I think that is a huge win for the plaintiff. I think it's bold, I think Mark Tinsley took on a big job you're bringing a civil lawsuit for something that law enforcement, the local prosecution team decided not to charge. So, and he's got some reasons we've gotten to explore on our first stream of the Spivey case. We looked at some of the backing, and there might be an explanation there that makes sense why law enforcement and prosecutors didn't want to pursue this case. But still, I think just abstractly, the idea of pursuing civil damages for something that's a criminal act when nobody wanted to pursue criminal charges or found that the defendants were immune from criminal prosecution, that's a big uphill battle. So I think that's, a huge win. I think expressing my opinions, I didn't really see compelling arguments from Boyd's attorney, and I don't know. I just think that Kenneth Williams, I think he has slightly better facts because he's the passenger. He's the one being asked to delete stuff. Sure, it doesn't look good that you are deleting stuff. It doesn't look good that you are changing your story for your buddy friend, but maybe there's a defense in there some way where, well, my buddy friend is buddies with the law enforcement. I don't want to be the one that this gets pinned on if I don't acquiesce to this guy that has friends with high power, places of power. I don't know. I think the facts are slightly better for Williams as the passenger. And I think I enjoyed his attorney's arguments more. I enjoyed the questions he was asking witnesses more. I also thought he was more entertaining to watch. So, if Williams and Boyd are still going to stick with the same story as this case proceeds, maybe they'll riff with each other a little bit, because it might not be in their best interest to continue down the same path, locked hand in hand. But if they stay together, I think that's a good benefit for Boyd, because I think some of the advocacy of Williams' attorney has been stronger than the advocacy, in my opinion, that I've seen from Mr. Moss. So, Afro Man is getting sued. What? Oh no, why? Let me Google. Afro Man to stand trial this month. Do we have to watch a trial, guys? Oh no, I feel like I'd want to watch this. Afro Man to stand trial this month. Let me put this in a reader mode. Afro Man to stand trial this month over music video made from deputies' raid footage. Oh, I think I saw like a post about that. I didn't see the video, but like it had the thumbnail and it looked like footage, like body cam or something. Yeah, so rapper Afro Man is set to stand trial March 16th after Adams County deputies sued him over a music video he made using security footage from a 2022 raid on his home. Huh. I mean, do they have an expectation of privacy when they're in his home? What's the basis for this? I'm already curious. Afro Man's the guy that made the song Because I Got High and Colt 45. That guy Nick says, oh my god, it's so stupid. It sounds stupid. Nick says Tinsley was nailing them on the specific elements of immunity. I really enjoyed seeing the advocacy and arguments. And I know I'm making the bap a clip, but I still enjoyed Stick Lawyer Guy. I enjoyed his advocacy. I'm gonna laugh at it, but it's kind of laughing with the joke, with the stuff he's doing to make his point. Let's see. Jerome showing love to Amy E in the building. Heck yeah. Hey, Lady L. We've got... I haven't seen Flesh of the Gods for a little bit. I gotta go be like, where are you? Flesh of the Gods, the source. Another name change that I've gotten adjusted to that name change. I gotta get used to the Song of the Night being a distinct channel now still. Let's see. Yeah, Ajax says, well, it's either citizen's arrest or false imprisonment, one or the other. Yeah, I wouldn't want to be in a position where I'm risking such a thing. Like, first of all, I don't think I'd be the best person. like, especially if I'm unarmed and don't know if the other person's armed. I don't think I'd be physically situated. I don't think I'd be in a good position. I wouldn't be in an advantage to like hold down an average person. Like maybe I'm 5'9", but so slightly, maybe slightly above average. I got more to work with. I just don't think I would be very effective as a citizen's arrest. Like it would be more dangerous for me to try. So even if it's an option, it's probably not going to go well. It would just be unreasonable. Let's see. All right, the video will answer my question. All right. Well, I'll watch it off. I'll look it up after the stream. I'll tell Classy to play it tonight. I love Classy. Thank you again for another 10. Let's get some W's in the chat for Jerome Street. First of all, it's good to see you. It's been a minute. Thank you for showing love coming in here. Showing love to everybody. And sending in some supers, showing some love. Oh my goodness. We've got Grandma Ninja in the building. Heck yeah, it's late to class. It's okay. I mean, we read the decision, but you know, it's just the denial of the immunity is the ultimate too long. Didn't read takeaway. So, yeah, I'm 5'9". So I have, you know, especially since I changed desks, it's a little shorter. I feel like I'm like slinking more. So I feel like my back's been I gotta remember to sit up straight. I feel like my posture's been slouchy, so maybe I'm like 5'8", depending on my posture for the day. So, same height here as Nem. Oh yeah, okay. Hey Kelly, let's get into this Afro Man story. So, he uses this security footage from a 2022 raid on his home. Adams County deputies raided the home of Joseph Foreman, better known as Afro Man, with a search warrant tied to an investigation into possible drugs and kidnapping victims. No charges were filed after the raid, so they didn't find anything. Deputies seized thousands of dollars in cash. Okay, well, they found cash. They don't file any charges, but they found cash, which was later returned. But Afroman said about $400 was never recovered. Afroman said the raid left damage throughout his home, and that the Adams County Sheriff's Office told him it was not responsible for paying for repairs. In a quote here, the guy started laughing and waddling his head and said, was he like, what is it, the Jennifer Nichols head move? We're not required to do that. They were unapologetic, Afroman said. Afroman said he turned the experience into music. This must be the video, so let me drop this link. Well, maybe it's the video. It looks like an interview with Afroman and video clips. So dropping that in the chat. I'm going to look up the video on YouTube after I end this stream. But, you know, Because I Got High is a hoot at karaoke. If you ever need a song that's like not too, you don't have to have like Christina Aguilera vocals. You can just do Afroman. And the crowd's gonna love it. The crowd's gonna go wild. They'll be like, I remember that song. So he turned the experience into music using his own security footage. So it's his own security footage. It's not like he's using body cam footage or anything, which is also kind of public, but maybe there's a gray area. You're not supposed to use it commercially. It's his own security footage. So that takes away another question I had at the beginning of this article. His own security footage from his own property. What state is this? Ohio's a one-party state. Right? Is Ohio a one? I don't trust these AI results. One-party consent state. Because the answer was like, it's a two-party state, Democrat and Republican. That's not what I was asking. Yes, Ohio is a one-party consent state. God, we're going to watch this trial. If this is televised, we are going to watch this. This sounds like a mess. So it's his own security footage. It's a raid on his home. And it's a one-party state. So he uses this in a music video to help pay for the repairs. Quote, I use my personal life to write my music, he said. Will you help me repair my gate? Will you help me repair my door? I'm singing about what actually happened to me. So are they going to say it's like defamatory because it's not what actually happened to him, even though it's on video and the video shows the video? This is a mess. Oh my God. Deputies who appear in the video are now suing the rapper for damages caused by their likenesses being used in the video. Their likenesses? Does he use like part? Does he do like part, like it's not all just footage from the security camera? And I don't know, isn't part of using likeness when it's unauthorized, like, I don't think it's just you can't use likeness at all. You can't commercially use somebody's likeness that they didn't approve of. But if you have someone reenacting something, that doesn't necessarily mean you're using somebody's likeness. And if you're going to argue that you shouldn't use the security footage because it's your likeness, it's literally you. And your consent is not... I don't know. We need to get somebody from Ohio that practices in this thing, this matter. I mean, potentially criminals, a criminal defense attorney. I'd like to hear his commentary on this anyway, just because I'm sure he'd have some colorful words for the officers being crybabies. But is this really like an IP, a likeness issue? Maybe. So anyway, Afroman files a countersuit for the damages to his home. Judge Jonathan P. Hine dismissed those claims in February. So the countersuit was dismissed for the damages, but that would be more of a like qualified immunity. I saw a headline today. It popped up on my news ticker. It's like, when I was getting arrested, my water was running, and I asked the cops if I could turn my water off, and they wouldn't let me turn my water off. So now I had flooding damages. And probably not liable because cops are just doing their cop things. So this seems like a separate issue. I don't like that they dismissed all of my claims with the click of a button in some little office somewhere without a hearing. I feel that. I understand that. But this is qualified immunity. And maybe a good reason why we should consider changing that. Afro Man said the lawsuit against him is not just about money. He believes it is a violation of his freedom of speech. I mean, I agree. I should have freedom of speech. I should be allowed to speak out about my life, and police officers that violate my home and steal my money should not be allowed to sue me, he said. I agree. I agree. So, and this is specifically, if on one hand, this is so interesting. So on one hand, if the cops are immune because of qualified immunity, and that same transaction that they're arguing they have qualified immunity during was on the security footage video. That is the transaction. Then the freedom of speech issue is serious because it's restricting someone's ability to explain what an agent of the government was doing. It's not just like, hey, a private citizen is suing me because of something I said. This is someone who's a government employee, they're a law enforcement officer, is suing me for my commentary, something I'm speaking on, within their duty as a law enforcement officer. Because I'm speaking on this transaction that they're already saying was qualified by qualified immunity, was covered by qualified immunity, which means in the course of them acting in their government role as a law enforcement officer. So then to try to stifle that, even though they might be suing in their personal capacity, now you're applying something different, a different standard. So this is really interesting. This is really interesting. Because are they going to have to argue? I agree. He should be able to speak out against government violations. And they should not be allowed to sue me. And do we have this? Oh my God, can you imagine if this went to the Supreme Court of the United States? We get to hear SCOTUS arguments about Afro Man. Oh man, take it all the way. Take it all the way. Guys, I'm hooked. I'm hooked. We've got to watch this. Yo, shout out. It was Tony that brought this up, right? Wherever. I think it was Tony. There we go. Oh man. What a well worth it rabbit hole. Yeah, we're gonna have to tell Sean he's got to get on this and cover it. Can you imagine if, what is it, IJC? I forget their name. Injustice something something. IJC. I know that's very helpful. IJC. But they represent a lot of people. They just won a case. The heck is the guy's name? I can picture his profile picture. And they also did a lot of work for that. Do you guys remember that Atlanta no-knock raid? Where they like went to the wrong house number. And the family brought a civil suit, and it was a question of, like, did they have immunity for these damages here? And I think it went all the way up to SCOTUS. And, oh my God, what the heck is that company, the organization's name? It's a nonprofit. This is going to drive me nuts. Institute for Justice. Institute for Justice. So it's just IJ. There's no C. All right. Who's their team? Let me find. Patrick Giacomo, I think is who I'm thinking of. But he was just tweeting about a case where it was the first a First Amendment issue. Let me find it. Hopefully he doesn't tweet a lot. I should play some Jeopardy music while I find this. Everybody just guess acronyms. I added a whole extra letter. That's why I couldn't find it. Yeah, he does a ton of these cases. Is it McCarthy? I think this is it. Okay. Motion to dismiss denied. Our case against the federal government and the U.S. Marshals. Nope, wrong one. Noah Peterson. I think this is it. It was a pleasure to chat with John about IJ's latest free speech victory in our campaign against First Amendment retaliation. Just last week, we landed, Chuck Morris, not Norris, landed a massive victory for Noah Peterson against the petty tyrants of Newton, Iowa. So let's see. Does this give the full story? I remember reading the details of this story. I promise. It was like a free speech thing. They were trying to silence him. They wouldn't let him talk. And that's government censorship. That's like exactly what the First Amendment is for. All right, let's read this tweet thread. Maybe this will give us context. In Newton, Iowa, or maybe it's Newton, I don't know. I say things differently. In 2022, disgraced police officer Nathan Winters falsely arrested Taven Galanakis, or I wonder if there's any relation to Zach, a completely sober college football player for DUI. The local kid, Noah Peterson, was outraged and calmly criticized the Newton Police Department, as well as the Newton mayor, during a city council meeting. So this is at a city council meeting, where the public can go and speak. The ignorant and corrupt mayor ordered his arrest in violation of the First Amendment. The Institute for Justice took on his case, filed a lawsuit, and just scored a huge win for free speech. I got the chance to speak with Patrick Giacomo about the case. So whatever I read was more, but let's watch this. I want to watch this. This will be the last rabbit hole we go down, though. I'll share this full link. I'll share this full video, but let's watch at least what happened to this guy at the council meeting where the public should have the option to speak. Yeah, Max says he got arrested for calling them fascists. Yeah, but this is exactly what the First Amendment is there for, you know. A lot of people, when it's private citizens going at it and they yell First Amendment, free speech, I mean, it's a stronger argument to rely on the First Amendment when it's the government trying to silence a citizen.
Do not address the chief of police in that manner. Continue on.
I address you too in that manner too.
Noah had gotten up and criticized the police.
Do not address the chief of police in that manner.
The chief of police and mayor of this town are two top fascists, and they need to go.
There you go.
Ceased. He got arrested for it. He was told to be silent. He wouldn't. He got arrested.
Dang, they're putting him in cuffs right there at the public council meeting. Yeah, you can't do that. The government cannot arrest you for your speech. This was not threatening speech. This was not violent speech. Honestly, it's kind of confirmatory. Why would you do the thing that someone's verbally accusing you of being? What a mess, guys. I'm going to link to this full video here. But how cool would it be if, Afro Man's case, really, sticks it to these cops that are mad that surveillance or security footage from a device that Afro Man himself owns of incidents that took place in his residence. It's got their panties in such a bunch that they're suing him, but they also weren't responsible for any damages that the raid may have caused and or the missing $400 in cash that wasn't returned, that was alleged to have been taken and not returned. But they're covered by qualified immunity in that respect. But now they are mad that somebody's speaking out about what happened to them. Oh, this is a great First Amendment. I'm so excited for it. Well, chat, that's that. If you're looking for something to do on your Friday night, consider playing some Afro Man. Watch that video. I'm going to look up that video and watch the surveillance footage when I get off of this stream. Let me also drop the link to Patrick Giacomo. I think he does a lot. He posts several updates of like SCOTUS cases. So a lot of times when Supreme Court decisions come down, like everybody's like, oh, breaking news, the Supreme Court just issued a decision in XYZ case. But I think Patrick also posts like cert updates. So if a case is like, hey, Supreme Court, we want you to hear this case, please grant us our petition for a writ of certiorari, because we want you to address this very important constitutional question. And then the Supreme Court, months before we actually see oral arguments, sometimes years before we see a decision, they might say, hey, yeah, we'll agree to hear this case. We want to address this legal question. We either want to clarify something or consider something for the first time. And you don't really get to see too much news about cert being granted in cases. And I think Patrick posts a lot of those updates. I'll start retweeting those if you guys are interested in hearing when SCOTUS is going to take up a case. There's his ex. We're talking about cake. Lemon pound cake. There's a lemon pound cake in the video. I'm going to look for it. And Grandma Ninja, thank you for being a member for 11 months. Says it's a freaking YouTube community trying to F with him. For... Wait, white or YouTube? Sorry. It could go either, but I'm reading this in the context of YouTube. So I don't know. And it could be either, right? Is there like, are there creators on YouTube here making videos about him? Oh, man. Nah, this is the type of thing, and the stream we did earlier today, we were talking about Killer Mike, and Killer Mike, I think he does a lot of political commentary and commentary on other issues as well. But one of the things I like about people like Killer Mike in general is they're willing to have conversations. He's got a whole podcast just called Conversate. Like, that's the point, and having conversations. And when there's something like free speech and cops want to sue you for like talking about what they're recorded doing in surveillance footage, why should anybody disagree that we should have concerns that the police or anybody from the government is trying to say you can't speak on the things that the police or the government are doing? And I think that's kind of a united front a lot of people should be concerned about. So let's see. I think we've gotten caught up here. Back on the cake here. Everybody, I hope you enjoy your Friday. Is Nick Starro still live with his panel show? I think I saw he started earlier than usual, so I wouldn't be surprised if he's still going, but let me just double check. Yep, he's still live. So let me set up a redirect. We'll go hang out over there. Tell him to look at the Afro Man case. He'll probably have a similar reaction, like reading the details as I did. Like, wait, it's his own footage? In his own residence? They're saying he can't talk about it? I can picture a very similar reaction there. So, all right, we've got... I'll drop the link to Nick in the chat. And I'll set up the party bus that we'll take over there. Hey, Biz. Good to see you. Good to see you. Good to see you. Gotta watch this from the beginning. Let me tell Tay Biz. We go down 3 other rabbit holes. In case he's in the past and not hearing me live, shout out to Tay Biz. Big love for Tay Biz here. Always love when he pops in. DB's in here and just... what are you even correcting? He just pops in to correct a typo, but he didn't say anything previously. Good to see you guys. Miss you right back, Jerome Street. I think Nem pointed out I had like a week where I didn't stream. I've been so swamped trying to get stuff done for work. And that's a whole long story. I'll do like a members only stream one of these days to gripe with love about my job. Because I still have love for them, but they annoy me sometimes. Anyway, we're going to go over to Nick's, and I'm going to keep rolling through these catch-up cases, getting caught up. We'll add the Afro Man trial to the roster. We're going to keep going. We're going to keep trying to get caught up. See you guys tomorrow.